This is The Chris Berry Show. Expert information on wealth, estate, and tax planning for the second half of life. Information that you can understand. Here's your host, Chris Berry.
Welcome to The Chris Berry Show, where we talk wealth, estate, and tax planning for the second half of life. And happy Veterans Day, everyone. I want to take a moment and just thank all the veterans and surviving spouses of veterans and family members who had sacrificed for those veterans. And today what we're going to do is we're going to dedicate this show to the veterans, with this being Veterans Day. And we're going to spend some time talking about veterans benefits. And for any of the listeners today, if you give us a call, what we'll do is, if you give us a call, we'll set up a free financial and medical power of attorney for any veterans or surviving spouses, as long as you call today on Veterans Day, or if you give us a call tomorrow, which is Veterans Day observed, being Monday. And if you are a veteran or a surviving spouse of a veteran, give us a call at 810-355-2584. And you have to give us a call either today on Veterans Day or give us a call on Monday, tomorrow, on Veterans Day observed. And what we'll do is we'll set up a time to provide a free financial and medical power of attorney for any veterans or surviving spouses of veterans. And it's our way of thanking those who have served, those who have put their life on the line for our nation, and we appreciate that. So today on The Chris Berry Show, we're going to spend some time talking about veterans benefits and how there's really two main types of veterans benefits. And then in our third segment, we're going to get into some of the questions and answers. So some of the questions that our listeners have submitted, either via phone at 810-355-2584, or via the interwebs. You can send us an email anytime at askchris@thechrisberryshow.com. Or if you go to our website, thechrisberryshow.com, you can click through and submit a question right there via the website. And on the Chris Berry Show, we like to start off every show with a positive focus. And so the positive focus I want to share is actually a new project that we started, where if you're thinking, you know what, I haven't gotten enough of Chris, one of the things we've started is a fun little 3 to 5 minute video, educational video, called Barry's Bites, where I talk on a topic very briefly, something that maybe's come up in the office. And it's usually a 3 to 5 minute video. And what we do then is transcribe it so you can read it if you're more of a reader. But if you go to the website, thechrisberryshow.com, in the upper right, there's a link where you can click through and you can see some of those previous Barry Bites, where we talk legal, financial, and tax planning strategies. And then also, if you're at our website, The Chris Berry Show, then one of the things you can do is register for one of our upcoming workshops. So on the top right of the website, you can see a link of our upcoming educational workshops. We call these clarity building workshops. And we do these workshops about once a week at one of our different locations, whether it's Ann Arbor, Brighton, Bloomfield Hills, Novi, or Livonia. And if you do want to register for one of those, remember seating is limited. And actually our next 3, it looks like are filled up, are full. But if you do want to register, you can go to thechrisberryshow.com, and there's a link where you can click through to register for one of our upcoming workshops. Or you can give us a call at 810-355-2584, and we can send you some information or get you registered that way. Or email us at askchris@thechrisberryshow.com. So with that, again, today is Veterans Day, so it seemed appropriate that we would dedicate this show to the veterans and surviving spouses out there. And we're going to do a majority of the show just talking about how the VA benefit works. And so I wanted to start off by just outlining that there's really 2 main types of benefits that are available. One is called the service-connected compensation, and the other is called the non-service-connected pension. So the way the service-connected compensation works is that if you are a veteran and you served, and because of your service you received some type of injury or disability or or symptom that could have been caused by something during your military service, then you may be able to get a disability rating. And with that disability rating, that can open up some benefits that are available to you. One of those would be a monthly benefit, as well as some health care, and depending on your disability rating, you can even receive potentially nursing home care at one of the VA nursing homes, one being in Marquette and the other one is in Grand Rapids. But with that service-connected compensation, what happens is that you need to have maybe been shot during service or maybe exposed to Agent Orange, and now because of that exposure, that service, you now get a disability rating where it's kind of like a workman's comp type situation where based on your service, they want to make you whole, so to speak. And it's a tough program. It's tough to get those benefits, and there's a lot of veteran service organizations out there helping veterans secure their service-connected compensation. But based on that disability rating, you could get another $1,000, $2,000, maybe over $3,000 a month. So that's called the service-connected compensation. Easy for me to say, right? Service-connected compensation. On the other side of the coin is what's called non-service-connected pension. A lot of times this is generally called the aid and attendance benefit. Now, technically, you can get aid and attendance on the service-connected side as well. But a majority of people, when they're talking about the VA benefit, the aid and attendance benefit, they're talking about the non-service-connected pension. And so this is a benefit that's available to veterans and surviving spouses who meet certain requirements. And one of those requirements is that, or one of those things is that you don't have to have been injured during a period of conflict to receive this benefit. So let's talk about how this non-service connected pension, the aid and attendance benefit, works. And I want you to understand that we actually have kind of the old rules and the new rules. And if you've been a listener of the Chris Berry Show, we talked about this recent rule change. But the way the benefit used to work, the aid and attendance benefit, the way it used to work is that if you meet certain requirements, and there's 5 requirements, if you meet all of these requirements, then we could bring in an extra $1,000 to $2,000 a month tax-free to help pay for long-term care. And so those 5 requirements are, first, 90 days active duty. So we need 90 days of active duty. That means you cannot have been in the reserves for that entire time. You need 90 days of active duty. So basically 3 months worth of active duty. And it doesn't need to be continuous. It could be at different times. But we need a total of 90 days active duty. And then the second requirement is that one of those days of active duty has to be during a period of conflict. So it has to be during a period of conflict. Now, you don't need to have been serving in a military or wartime setting for this to work. So you don't have. It's not like you have to have been in Vietnam. You could be pushing paper in Michigan, but as long as one of your days of active duty was during a period of conflict, then you're going to pass this test. So it's not like you have to have seen combat even. You could have been pushing paper in Michigan, but as long as one of your days of active duty occurred during a period of conflict, then that works. And periods of conflict have been defined by Congress. So we can go to the VA website to see what those periods of conflict are. But basically, it's going to be World War II, Korea, Vietnam, and then the Persian Gulf conflict since the 90s and onward. And now, there are some exceptions. So, for example, with Vietnam, if you're boots on the ground in Vietnam and you can prove it, then even though it was prior to the period of conflict, then that still might work. So there are some exceptions. But basically, one of those 90 days has to be during a period of conflict. And then the third requirement, pretty straightforward, cannot be dishonorably discharged. So if we have an honorable discharge, then that'll work. And so this information, the 90 days active duty, 1 day during a period of conflict, cannot be dishonorably discharged. We get all of that information from your separation papers or your DD-214 or your discharge papers. And that really is probably the most important thing when it comes to planning or trying to apply for this VA benefit is making sure that we have those discharge papers. So if you're considering this and you don't have a copy of those discharge papers, make sure to go to the VA website or a veteran service organization at the county to put in a request to get those, because you do need an original or a certified copy of the discharge papers. So again, 90 days active duty, 1 day during a period of conflict, cannot be dishonorably discharged. And those rules haven't changed. Those are still in force. Now, this is where it gets a little bit more complicated. So we have the first three: 90 days active duty, 1 day during a period of conflict, cannot be dishonorably discharged. Now, the fourth requirement and the fifth requirement, this is where there's been some changes. So I want to go over how it used to work prior to October 18th, and then I'll talk about how it works now, because there has been a change. So the way it used to work is the fourth requirement was an income test for the veteran or surviving spouse, where we would look at the amount of income coming in from really focusing on Social Security and your pension. That needs to have been offset by the amount of long-term care costs going out. So, for example, if we had a veteran who had a Social Security of $1,500 a month, and then we had a pension of $400 a month, that would be, not that I'm good at math, but $1,900 a month coming in from Social Security and pension. So that would be an income of $1,900 a month. And that has to have been exceeded by the amount of long-term care costs going out. So those long-term care costs could be things like home care. And speaking of home care, we're going to have Carrie Aiken on the show next week talking about the role home care can play in terms of managing or helping with the elder care journey. But let's say you're paying a home care company $2,000 a month. Well, that's greater than the veteran's $1,500 or plus the $400, greater than the $1,900 a month coming in. So as long as we have more long-term care costs going out to pay for home care, to pay for assisted living, to pay for nursing home, to pay for even a family member with a personal care contract, as long as we have more long-term care costs going out than income coming in, then we would pass the income test, which was the fourth requirement. So far we have 90 days active duty, 1 day during a period of conflict, cannot be dishonorably discharged, and now we need to have more long-term care costs going out than we have income coming in from Social Security and pension. And that brings us to the fifth test, or the fifth requirement to bring in that VA benefit. And again, if we meet all of these requirements, we can bring in extra $1,000 to $2,000 a month tax-free. So it's a great benefit. So the fifth requirement is an asset test. And this is where things have changed, so keep in mind. So I'm just talking about how the rules used to be, because it's important to understand where we come from to understand where we're going in the future. So the way it worked is that if you had roughly more than $30,000 to $60,000, depending if you were single or a married couple, if you had more than that amount of money of countable assets, you would not qualify for the VA benefit. So there was an asset test here. And I said countable assets. And so countable assets are basically everything other than a home, personal belongings, automobile, small cash value of life insurance, prepaid funeral. Basically, everything else was a countable asset. So if you had a second piece of property up north, if you had another car, those would be countable assets. If you have IRAs or 401ks, those are all countable assets. So if the veteran had more than, or veteran or surviving spouse had more than $30,000 to $60,000, they would not pass the income test and there would be no benefit available. And unfortunately, a lot of families submitted VA applications thinking that they could get approved or qualified, and for some reason, a lot of local veteran service organizations would go ahead with submitting the VA application, but they'd get a denial because they were over this net worth analysis, looking at the amount of assets the family had. So one of the things with this VA benefit prior to October 18th is that there was no look-back period. So they didn't look back in terms of whether you made any gifts or moved any money around to qualify for the VA benefit. So if you were a veteran or surviving spouse who had maybe $100,000, we could set up a veteran's asset protection, move the money into the trust. It could be accessed for care and needs, but because it was now in this veteran's asset protection trust, we could now get qualified for this VA benefit, where we could bring an extra $1,000 to $2,000 a month. Now, keep in mind that the purpose of this isn't to make sure the kids get some big inheritance or anything like that. The purpose of this is really to ensure that the veteran or surviving spouse receives the level of care that they need. Because when you start talking about long-term care costs of $2,000 a month, $5,000 a month, $8,000 to $12,000 a month, and especially if it's a veteran or surviving spouse, we want to bring in any benefit that we can, especially if it's a benefit that's available to help keep a veteran at home or help keep a surviving spouse of a veteran at home. If there's a way that we could bring in additional money to help do that, then I think that's very important for the family. So it's not like we're trying to make the kids rich with this or anything. Really, it was to make sure that veterans and surviving spouses were able to receive the best quality of care possible, because these are the people that put their life on line for our nation. So it was a powerful benefit. And so what I'm going to do next is I'm going to go over kind of how the rules have changed for veterans. So since October 18th, the rules have changed on how we get individuals qualified for that VA benefit. And depending on your situation, it might be a little bit easier or it might be a little bit harder to bring in that extra $1,000 to $2,000 a month. So I'm going to, in our next segment, go over how do we get qualified for that VA benefit now. And then in our third segment, we're going to get into some of the questions and answers from our listeners. So if you do have a question, you can email us anytime at askchris@thechrisberryshow.com or give us a call at 810-355-2584. So that'll be the third segment where we get into the questions and answers. And stick with me as we continue talking about the VA benefits.
The cost of care for an elderly loved one or a loved one with a chronic illness is shockingly expensive. If you are dealing with the unbelievable cost of care, make sure you get all the benefits you're entitled to. Here's certified elder law attorney Chris Berry from the Elder Care Firm in Brighton.
Most of my clients are really concerned about long-term care costs. They don't know where to turn, and what we can do is put together legal strategies to protect your resources and also bring in additional resources to help pay that cost of care. One of the things that they often say is that I wish I knew about this years prior. And unfortunately, the information's out there, but there's just so few certified elder law attorneys. As the only certified elder law attorney in Livingston County, it's my job to make sure that our seniors, our loved ones, our veterans have the best quality of care possible and the best quality of life possible.
Protect your hard-earned assets from probate, long-term care costs, and the IRS. The Elder Care Firm will get you the governmental benefits you deserve, including veterans benefits and Medicaid. Visit theeldercarefirm.com and schedule a free 15-minute phone consultation. That's theeldercarefirm.com.
Welcome back to the Chris Berry Show, where we talk wealth, estate, and tax planning for the second half of life. And thank you again so much to our veterans and the surviving spouses of our veterans out there and any families that have veterans. I want to wish everyone a happy Veterans Day. And today's show is dedicated to the veterans. So we're talking about the VA benefit, and specifically we're talking about how the differences between the service-connected compensation and the non-service-connected pension, which is called the aid and attendance benefit. And if you remember, or hopefully you remember because I just spoke about it, but there are 5 requirements to the non-service-connected pension, sometimes called the aid and attendance benefit. So 90 days active duty, 1 day during a period of conflict, cannot be dishonorably discharged, more long-term care costs going out than income coming in from Social Security and pension. And then the 5th requirement is an asset test. Now, I said the rules have changed, and they changed on October 18th. And we've talked about this a little bit on the Chris Berry Show, so make sure to go to thechrisberryshow.com to listen to past episodes, or if you are listening on iTunes via podcast, you can search for us there and listen to previous episodes of the Chris Berry Show there. But we had a big change with regards to the VA benefit, where we knew this change was coming, and it's been it's a rule change that's been proposed since 2015. So we've been working in this VA space helping veterans and surviving spouses since 2008. I was actually one of the first VA accredited attorneys in Michigan in 2008. And so for the past 10 years, we've been helping a ton of veterans and surviving spouses and their families get qualified for this VA benefit. And we're doing it the right way. We're making sure that the veterans and surviving spouses and their families kind of remain in control. But unfortunately, there's a lot of people preying upon veterans and surviving spouses, selling them insurance products that weren't appropriate for them. They were getting them qualified for the VA benefit, but they were putting them into annuity-type products that just weren't right for the family and really were only right for the person selling them. So this became a national news story where if you were to Google or look up pension poachers, there was even some people in Congress talking about it back in 2015. And so in 2015, they had a proposed rule that was going to put a 3-year look back on this VA benefit, with the idea that these people who are preying on these veterans wouldn't be able to do this anymore. But unfortunately, with that 3-year look-back period, really the only people you're hurting with this change is actually the veterans and surviving spouses, because those insurance salesmen, they're just going to find the next thing, the next way to sell their insurance products. So with this change, we knew it was coming ever since 2015. And every year, at the end of the year, we would see the forms inside the VA change to say maybe a December rollout of this 3-year look-back period. And so 2015, we thought, well, maybe it's going to be effective in 2016. Well, 2016 goes by. We see them make a change internally at the VA where it looks like it's going to be effective of December 2016. Well, that passes without a change, without them implementing the new rule. And in fact, with this proposed rule change, there was over 900 comments with your radio host here being one of those commenters saying that it really just hurts the veterans. So with all these commenters, we thought maybe we could buy some time or put this rule on hold, or maybe they'd rework it, understanding that really the only person we're negatively impacting are veterans and surviving spouses. And so 2016 goes by, still no change, still no implementation. And then 2017, again, we see them internally near the end of the year change their internal forms where we think, maybe the writing is on the wall, maybe this change is going to be effective. But again, 2017 goes by and again, no change. And during this time, we also had a change in presidency. So we're kind of thinking that maybe this 3-year look-back period was going to go by the wayside, that it wouldn't be something that would have to happen. Well, so 2018, we're marching right along. And again, we see the changes internally at the VA. We hear some rumblings that it'll be effective near the end of the year, and so we're ready for that. And then September 17th, myself and some of my colleagues saw that there's going to be a final rule released on September 18th. And so this was, we knew it was coming, but we're just surprised it did come. And then when we actually looked at the rule, this was a surprise to all of us. We thought it would be effective maybe December at the earliest, or really we thought it would be effective for 2019. But lo and behold, they inserted language in there to say that the rule was going to be effective 30 days after it was published. And so what that meant was that we had about 30 days to help a bunch of veterans and surviving spouses get their applications submitted prior to this October 18th date. And we were able to help about 15 veterans and surviving spouses and their families bring in this additional benefit in that month. And you could just see the reliefs on these families' faces when they knew that they're they would get an extra $1,000 to $2,000 a month to help care for a loved one. And really, it was the difference between maybe mom or dad having to go in a nursing home versus mom or dad getting enough care at home to stay at home longer. So it's a powerful benefit. But this rule change was coming. And so what happened was October 18th, since October 18th, we now have a 3-year look-back period for this VA benefit. And also they changed the net worth analysis as well. Basically, it looks like what Congress did is take some of the Medicaid rules, slap them, change them around a little bit and try to force it into this VA environment. So some of the rules follow some of the same rules that Medicaid follows in terms of look-back periods and that type of thing. And some of the rules are completely different. So it's important if you are a veteran or surviving spouse that you get expert knowledge on this if you try submitting a VA application. And this is one of the things that we talk about at our workshops. So if you do want to learn more about this VA benefit and how it works now with this law change, please visit us and attend one of our free educational workshops that we do at one of our different locations, whether it's Ann Arbor, Brighton, Bloomfield Hills, Novi, or Livonia. And you can get information on those workshops by going to thechrisberryshow.com and click through, and there'll be a spot where you can see a list of our upcoming workshops and also register. Or you can give us a call at 810-355-2584. We can get you registered for one of our upcoming workshops, or we can send you out some information on that as well. So we had this rule change. October 18th. And now we have a 3-year look-back period. And we have a different way that this net worth analysis works. So basically what they've done is they've taken the Community Spousal Resource Allowance from Medicaid. So basically what they're saying is that a veteran or surviving spouse, whether married or not, can have up to $123,000 of net worth. So what is net worth for VA purposes? Basically, the way it works is they look at net worth as a combination of assets and income. So we look at the amount of countable assets you have. So let's say you have $100,000 of countable assets. Okay, so in terms of the net worth analysis, that's $100,000. But then let's say you also have a Social Security and pension of $2,000 a month. Well, $2,000 a month times 12, again, I'm not good at math, but let's call that $24,000. With that $100,000 of liquid assets, countable assets, plus the $24,000 of income you have coming in from Social Security and pension, that would equal a net worth analysis of $124,000, which would put you over the limit for VA purposes of that $123,000 limit. So basically what they're doing is they're combining to reach this net worth analysis, what they're doing is they're combining your income as well as your assets into one number. Now, if you do have long-term care costs, that can offset some of your income. So if we are paying for home care, if we are paying for assisted living, if we are paying for nursing home care, or if you have a family member other than a spouse who's helping provide care, one of the things we could do is set up a personal care contract to pay that family member. So maybe to pay the son or daughter who's had to put their life on hold to become a full-time caregiver, we could set up a personal care contract, and it has to be in writing. So don't just go and pay a family member, because you could run afoul of VA as well as Medicaid if you were to do that. We need to put together a personal care contract that's drafted properly. So if we put together this personal care contract, then we could pay a friend, a family member, someone other than a spouse, and that could be long-term care costs that could offset that income. And now there is a 3-year look-back period, and the way that it works is that if you were to gift any money away, and again, you can make gifts for gift tax purposes, but you cannot for Medicaid purposes. So if you need nursing home care, a gift could penalize you from Medicaid if you're to have a stroke and now need long-term care in a nursing home. But now also gifts can penalize you not only for Medicaid, but also can penalize you for the VA benefit as well. And so they look back 3 years from the time that you try to apply for the VA benefit. And if you've gifted any money away, they're going to penalize you. And the way it works is they look at the amount of money that you've gifted away over the previous 3 years, and they're going to divide that by the divestment amount, or divestment divisor, which is basically 1 month's worth of your maximum VA benefit possible. So let's say you were to gift away $200,000 of assets, and that's that $200,000 would then be divided by, let's call it $2,000 and change, which is about the maximum monthly for a benefit, a veteran. A married veteran, and that would be your divestment amount, which would be the number of months that, even though you're under the asset test for VA, you wouldn't be able to qualify for that VA benefit. So it easily could be over 3 years. So with a lot of veterans now, you have to take into account this look-back period that we didn't have to take into account previously. Now, with that, there's still planning opportunities. So if you are a veteran or surviving spouse who may need long-term care either now or in the future, there's some things we can do to set the table or to help you get that VA benefit as soon as possible. And so, for example, I was meeting with a client a little while ago, last week, and her mom who's 92, was going from living at home. Now she needed assisted living because of her dementia. It's finally catching up with her, and it wasn't safe for her to be at home anymore. But the assisted living they are looking at, they're moving mom from Shelby Township to close to where they live so they can kind of check on mom and visit her. But now she's going to be in Northville, and the assisted living that they're looking at is going to be upwards of $5,500 a month. And that's pretty reasonable when it comes to assisted living or assisted living with memory care. So she had this outgoing expense of $5,500 a month, and she had a Social Security and pension of $1,900 a month coming in. So mom was going to have the shortfall of over $3,000 a month that was going to draw on her assets. And so they wanted to get qualified for the VA benefit. But I told them because of this law change, October 18th, mom wasn't going to qualify right away for that VA benefit. But in this situation with mom having long-term care costs exceeding her income, we had to figure out this net worth analysis, how to get mom qualified for the VA benefit as soon as possible. So what we're able to do is, in this situation, they had a home, and they were planning on selling the home. So we're able to move that home into a trust so the proceeds of that sale would be protected inside of we call it a Veterans Asset Protection Trust. And then mom had about $150,000 left of countable assets. And so what we instructed the client to do, and again, take it for what it's worth. This isn't legal advice for you. This is just a hypothetical, so to speak. Make sure to sit down with a professional for your own planning. But what we're able to do is set up a plan so that with this shortfall, monthly shortfall, mom would qualify for the VA benefit in about 5 to 6 months once she's moved into the assisted living, because of the shortfall she had every month, and that was going to bring her below the net worth analysis. And then because of the planning that we did with that Veterans Asset Protection Trust, we were able to protect the proceeds of the sale of the home, because mom is going to continue to have the shortfall. So by bringing in the VA benefit, we're going to bring in an extra $1,000 a month to help plug up that shortfall, but it's just a Band-Aid. She's still going to have a shortfall. But because we move the house into our asset protection trust, not a revocable living trust, but a Veterans Asset Protection Trust, we're going to be able to get mom qualified for the VA benefit in about 5 months, and then the proceeds of the sale will not disqualify mom from the VA benefit. She'll continue receiving the VA benefit, but now she'll also be able to access the funds in the trust to make sure that mom has the best quality of life possible, that she receives the care that she needs. So I think it's important to understand how that VA benefit really can benefit families. So if you are a veteran or surviving spouse out there, or family members of veterans, thank you so much for your support. Please, if you are a veteran or surviving spouse and you do want a free financial and medical power of attorney, give us a call either today or tomorrow at 810-355-2584, or shoot us an email at askchris@thechrisberryshow.com. And so with that, I want to thank you. It's been a pleasure helping all the veterans and surviving spouses that we've helped. We continue to look forward to helping them in the future. And stick with us in the next segment as we answer some of our listeners' questions and answers. Thank you.
If you or a loved one is facing long-term care costs, make sure you talk with certified elder law attorney Chris Berry from the Elder Care Firm, like Sherry Skelton and her family did from Fenton.
It's really scary when you know that your parent deserves a certain quality of life and you're not able to afford it unless you get these benefits. And that was the place where we were at. We were like, we couldn't take care of her. We all had families of our own. We all worked. And of course, we wanted her in the best possible place that we could afford. And none of that would have been, we never would have been able to do that if it wasn't for them. I always recommend Chris. And I always tell people when they have any questions, I just say, you know what, you need to contact this guy because I can't even begin to tell you what he did for my family.
Hello, I'm attorney Chris Berry. The Elder Care Firm is here to help you and your family find solutions. Call us today.
Protect your assets from probate, long-term care costs, the IRS, and get the governmental benefits you deserve. Visit theeldercarefirm.com today or call 810-214-3800.
Welcome back to the Chris Berry Show, where we talk wealth, estate, and tax planning for the second half of life. And again, thank you to all the veterans and families and surviving spouses of veterans. We appreciate your service, and today we're honoring you. And so one of the things that we're doing, so if you call in either today or tomorrow, which is Veterans Day observed, so if you call in either today, Sunday, or tomorrow, Monday, and give us a call at 810-355-2584. What we'll do is we'll schedule a time for any veterans or surviving spouse of veterans. We'll do a free financial and medical power of attorney. Again, a free financial and medical power of attorney. So if you're a veteran or surviving spouse, or your mom or dad is a veteran or surviving spouse, and they need to get their disability documents in place, give us a call either today or tomorrow, and this is free to any veterans or surviving spouses at 810-355-2584, and we'll schedule a time to put that together. Again, 810-355-2584, or email us at askchris@thechrisberryshow.com. And these documents, they're vitally important. Really, anyone over the age 18 should have a financial and medical power of attorney in place. And so to honor our veterans and surviving spouses, we'll put together these free documents for you at no cost. Now, in our third segment of the Chris Berry Show, we always get into the questions and answers. Well, almost always. But today we will. And so our first question today is from Jed. And Jed asks, if one has to go into an assisted living, can veterans benefits cover some of the costs, even if you have savings and investments? Writes in Jed. While my dad has his savings in a trust, he knows that if he has to go into an assisted living facility or nursing home at some point, he's concerned that all of his money will be used to pay for living in the facility. And as a World War II veteran, he wanted to know if the VA would offset some of the costs. And he wanted to know, how much is he legally allowed to keep? Well, Jed, thank you for that question. I appreciate that. And thank you to your dad for his service. So to answer your question, we covered this a little bit in the last two segments, so hopefully that was helpful for you, Jed. But we'll dive into this again a little bit. So the question is, how do we pay for assisted living or home care or nursing home care? And we do have this VA benefit. And remember, the rules have changed now. So prior to October 18th, even if your dad had assets, we could set up an asset protection trust and move the assets into the trust and then get qualified. But now, post October 18th, we're now dealing with a different governmental or a different way that the VA program works. So now we have that 3-year look-back period that we have to be concerned about. So you mentioned that your dad has savings in a trust. So my guess is that he has his money in a revocable living trust. And unfortunately, a revocable living trust really doesn't offer any asset protection. It doesn't protect for the VA benefit. It doesn't protect for Medicaid or nursing home spend down. It doesn't protect against lawsuits. all that revocable trust does is avoids probate and controls the distribution upon death. So it's important to have that, but understand that it doesn't do anything to help your dad get qualified for the VA benefit. Instead, what we'd have to look at is something called a Veterans Asset Protection Trust. Now, at this point, setting one up for your dad may or may not make sense. It kind of depends on the situation because we do have this 3-year look-back period. So if we think we can set up a trust and make it 3 years from the time we move the assets into the trust and then qualify for the VA benefit, then that might make sense. And as a World War II veteran, it sounds like he meets most of the requirements, so serving 90 days active duty, 1 day during a period of conflict, and I'm guessing he wasn't dishonorably discharged. Then what we need to take into account then now is that net worth analysis, where your dad has to have some type of long-term care costs, whether it's home care or assisted living, and then we get into the asset part of the net worth analysis where we look at the amount of assets your father has. And so it sounds like he has some money, has some investments there. And if he has roughly more than maybe $100,000 or so, chances are he might not qualify for the VA benefit. And that's where if he's over in assets and we have some time, maybe it would make sense to set up a Veterans Asset Protection Trust, which is different than the revocable trust. But Veterans Asset Protection Trust, move the assets into the trust to start that 3-year clock running. So if you do want more information on this, what I'd recommend is that you give us a call and schedule a time to show up to one of our clarity building workshops that we have throughout Metro Detroit at one of our different locations, whether it's Ann Arbor, Brighton, Bloomfield Hills, Novi, or Livonia. And we do these workshops about once a week, really to provide education and guidance to the Metro Detroit and Southeast Michigan area. Because we're big believers in education. That's one of the reasons we do the Chris Berry Show. That's why we've published some books on planning for the second half of life and the role of a caregiver and veterans benefits. So if you do want more information, Jed, I'd recommend you give us a call, attend one of those workshops, because it sounds like there's some things that your dad should be doing now to, at the very least, if we're not going to get qualified for the VA benefit today, which again could be an extra $1,000 to $2,000 a month tax-free, there's some things we should do to at least set the table so at the time of him needing long-term care, we can bring in that VA benefit. And the earlier we start examining these options, the more options we're going to have on the table. So, Jed, hopefully that was helpful, and please thank your dad on this Veterans Day for his service. And that brings us to the second question. And the second question is, can a person potentially subject to Medicaid rules have an executor of an estate set up a trust for them to receive an inheritance? And this is a question from Shane. We're in the process of getting our estate planning done. If we were to die on our upcoming trip, will a do-it-yourself will suffice for our situation? Well, Shane, you're asking about some complicated governmental benefits here, like Medicaid. And so I wouldn't recommend a do-it-yourself download something off of LegalZoom solution here, because it sounds like, getting to your question, can a person potentially subject to Medicaid rules have an executor or a state set up a trust to receive an inheritance? So Shane, what it sounds like is we're maybe leaving things to a beneficiary who might be receiving Medicaid. And so what you're going to want to do is set up what's called a supplemental needs trust or a special needs trust. And that's not going to be something that you can just download off the internet. It gets pretty complicated when you start dealing with governmental benefits, whether we're talking about veterans benefits or we're talking about Medicaid, whether we're talking about Medicaid in the nursing home, or if you do have a loved one who may be receiving governmental benefits due to a disability. So I would for sure not utilize that do-it-yourself option or write out your own will. I'd recommend that you sit with an attorney, one that specializes in that area, and probably you would want to sit down with a certified elder law attorney, which I am, of course. And so you could certainly attend one of our workshops to start that process and learn the different ways to leave things to your beneficiaries. So you can leave things to your beneficiary through beneficiary designations. But one of the things we talk about in the workshop is how having just a simple will that simple "I love you" will might not be the best option, leaving things to your beneficiaries. And it might be because of poor financial mismanagement, it might be because they're minors, or it could be because they're receiving governmental benefits. And if you're to leave it outright to them, even if it's through a will, they would be disqualified from those governmental benefits. So Shane, I'd recommend that you take a step up from that do-it-yourself solution and get with a professional. Now, our next question, what kind of power of attorney do I need for an elderly mom? Do I need a medical? What about financial? I need to make some decisions for her. And then what about what happens after death? And this is a question from Ron. So mom's starting to get worse with her health. What documents are necessary to act as a power of attorney with regards to real estate while she's alive? And then how do I take care of things after she passes away? Well, so Ron, it sounds like what you're going to need for mom is really what we call a comprehensive estate plan. So you need to have the important tools or the right documents in place while mom's alive, and that's going to come in the form of a financial and medical power of attorney as well as a personal care plan. And then you're going to need to have the right tools in place after mom passes away. And that's going to be a will as well as potentially a trust and maybe a ladybird deed for the home if there is a home. And Ron, this brings up a great question or kind of a misconception that a lot of people think that a financial or medical power of attorney continues to be in effect after a loved one has passed away. Unfortunately, no, that financial or medical power of attorney, when mom passes away, it ceases to be effective. And so now we need to rely on some type of other legal instruments to be able to take control of mom or dad's estate. And this is where we look to the process of estate administration. So really there's 4 ways that, Ron, you'd be able to get involved and transition money out of mom's name to wherever it's supposed to go. And so those 4 ways upon mom's death are first, joint ownership. So if you were joint with mom on a checking account, when mom passes away, that checking account goes to you. I don't recommend joint ownership for anyone other than a married couple, but that is one of the ways that assets can transfer out of someone's name upon death. The second way would be through beneficiary designation. So if mom has an IRA, now you need to be able to kind of get that IRA out of mom's name. You don't rely on the power of attorney upon death because that has ended. That ceases to be effective. And now you would rely on that beneficiary designation. So hopefully that IRA that maybe it's at TD Ameritrade, maybe mom has named you as a beneficiary. And then if that's the case, all you have to do is send in a death certificate, and then they'll transition that IRA to you, where now it might become an inherited IRA. So that would be the second way, is through beneficiary designations. Third would be through a trust. So maybe mom has a trust, or if mom doesn't have a trust yet, now might be the time, especially because you said she's getting up there in the age, now might be the time to set up a trust, whether we set up a basic living trust that avoids probate and controls the distribution, or we set up a castle trust that avoids probate, controls the distribution, but builds in asset protection for mom, protecting her from potentially the devastating cost of long-term care. And so if an asset doesn't pass through joint ownership, beneficiary designation, or trust, then it ends up going into probate. And this is something, of course, that we want to try to avoid. But through the probate process, that's where mom might have a will that will appoint you the personal representative, giving you the authority to basically wrap up mom's estate. But ideally, we don't have to go through probate, because probate, it's a court process, it's time-consuming, it's costly. 3 to 5% of any assets that go through the probate process typically get eaten up in costs. So again, Ron, it's more than just having a power of attorney. The powers of attorney are effective while mom's alive, and you want to have that financial and medical power of attorney appointing you to be able to make medical decisions. So the third piece of the disability document trifecta is that personal care plan, a document that gives instructions to your financial and medical power of attorney on how best to care for you. So those are the documents that are key while mom's alive. And then when mom passes away, that's where we have to rely on the tools of estate administration, joint ownership, beneficiary designation, trusts, and then if it doesn't pass through one of those first 3 ways, then it ends up going into probate, where you would become the personal representative. But again, we want to avoid that. So hopefully that was helpful, Ron. Again, a comprehensive comprehensive estate plan probably is the best route to go for mom. So next question, how should I invest $200,000 for 3 years if I want to use the money for traveling expenses? And this is from Sam. So Sam is 60 years old, single. He's in his own home, it looks like. And he writes, I have $200,000 to invest for 3 years. At the 3-year mark, I want to take monthly withdrawals of $100,000 per month for traveling expenses. I currently have a retirement income of about $2,500 per month. Where should I put the money for 3 years to hopefully earn, you're writing in here, a 10% on average if possible? Well, Sam, with these types of questions, I always have to go back to kind of what is the strategy. So before I talk about tools or products, I always like to talk strategy. And so we like to apply that bucket plan method of understanding kind of the time horizon that we're going to be utilizing for our different assets and investments. And typically we break it into 3 buckets. The first bucket is a now bucket, so that's money invested or that we might utilize over the next year. So that would be if you had a big trip planned within the next year. The next bucket is the soon bucket of money. So that's money that we're going to need over the next, say, 3, 5, or 10 years. And then the later bucket is money that's invested that we're going to touch later, and typically invested more for long-term growth or legacy planning. So Sam, what you're talking about is looking at money that you have that you're going to invest, that you're going to use in that soon bucket, that soon category of investments. And so typically here, you're looking for it says you're looking for a 10% return. Is it possible? It is possible, but understand if you're shooting for a high return, understand you're taking on a lot of risk as well. And one of the things that we caution is, especially if it's money that you're going to use sooner rather than later, if you have that money invested heavily in the market where you're chasing a high rate of return, like a 10% rate of return, then if you look at it in terms of the risk pyramid, you have to get pretty high up the pyramid to be able to potentially bring in that type of return. And so if you are shooting for that 10% return, understand that could be a big swing the other way. So you're taking on a lot of risk, and it could be a huge loss. And where that really becomes a problem is when you go to withdraw that money. So, for example, assume that you're retiring in 2008 and the stock market crashed, you'd be in a world of hurt as you're trying to draw that money because now your investments have taken a 40% decline. Similarly, with regards to how you're planning on taking this money out. So what I would suggest is that you look for a more reasonable rate of return, and then there's some different tools and options available for you there. So Sam, hopefully that was helpful. Might have to be a little bit more realistic with that rate of return, but there are some options there. So with that, I want to wish everyone Happy Veterans Day. Hug a veteran if you know one, or a surviving spouse. A salute to all the families that have veteran surviving spouses out there. Thank you for your service. Thank you for your contributions. Thank you for your sacrifice. And join us next week on The Chris Berry Show.
Learn more about Chris Berry and how he can help your family by visiting online at thechrisberryshow.com. That's thechrisberryshow.com. You can also call Chris Berry at 810-355-2584. That's 810-355-2584. This program content reflects the opinions of Chris Berry and his guests, not the elder care firm, Prosperity Capital Advisors, or the C.J. Berry Group, and is subject to change at any time without notice. Content provided herein is for informational purposes only and should not be used or construed as investment or legal advice or a recommendation regarding the purchase or sale of any security or to follow any legal or tax strategy. There's no guarantee that the strategist's statements, opinions, or forecasts provided herein will prove to be correct. Past performance is not a guarantee of future results. Indices are not available for direct investment. Any investor who attempts to mimic the performance of an index would incur fees and expenses which would reduce returns. All investing involves risk, including the potential for loss of principal. There's no guarantee that any investment plan or strategy will be successful. We recommend that you consult with a professional dedicated to your needs. This program is furnished by the Elder Care Firm.
The cost of long-term care can be overwhelming. If you're dealing with long-term care costs, make plans to attend the next free informative workshop from the Elder Care Firm in Brighton. They'll show you how to protect your hard-earned assets and obtain the governmental benefits you deserve, including veterans benefits and Medicaid.
Hello, I'm attorney Chris Berry. As the only certified elder law attorney in Livingston County, I have the knowledge and estate planning strategies to help you. When you call, reserve your seat at our next workshop or schedule a free 15-minute phone consultation. The Elder Care Firm is here to help you and your family find solutions. Call us today.
Spots are filling up for the next free Elder Care Firm workshop. Reserve your seat today by calling 810-214-3800 or visit theeldercarefirm.com. The Elder Care Firm also invites you to join them at this year's Walk to End Alzheimer's. The walk is on Saturday, October 1st in downtown Brighton. Call 810-214-3800 today.